Jai Hind everyone. I am Vikas Roshan, Assistant Professor, AKGEC Ghaziabad. The subject is Constitution of India, Law and Engineering. The topic what I would discuss today is contract law and laws at workplace. Means I would discuss some laws that is applicable with employees at their workplace. So the Contract Law or Contract Act, before I explain anything regarding this, I would like to just give an example that will help you realize that how much important this contract is for we all people. Suppose sometimes we make bet with our friend. Suppose you make a bet with your friend and that the World Cup will be won by France. Your friend says no, it will be won by Brazil, and you decide to that who will lose the bet will pay 1 lakh rupee. In this situation, suppose your friend wins the bet. Then in this situation, you have to pay 1 lakh rupees to your friend. Now your friend approaches you and asks for the 1 lakh rupees. In this situation, you can either pay 1 lakh rupee or you can deny, or sometimes you may be aggressive and you can hit a slap on his cheek. So your friend will realize that he made an agreement with me, but now he is denying, and rather than paying money, he is just torturing me. So your friend would be thinking that there must be a law like Contract Law, Contract Act that can safeguard his interest. So with this fun example, I just wanted to tell you that if the Contract Law, Contract Act is not there in existence in our country or all across the world, the situation would be very, very difficult. Nobody will trust anyone, and the role of court will not come into action. So, in light of this story, in light of this incident, I can tell you that what Contract Law or Contract Act is there. Actually, it is influenced by English law, and we know that it was made during British era of India. The Indian Contract Act 1872 prescribes the law relating to the contracts in India. The act is based on the principles of English common law, in fact, and it is applicable to all states of India. It determines the circumstances in which promises made by the parties to a contract shall be legally binding. Actually, in the example what I just told to you, the legally binding factor were missing. If you and your friend had gone for a contract and fulfilled all formalities that is required by the judiciary, that is required by our system, then of course your friend could not have faced the slap on his cheek. Rather, he could have got 1 lakh rupee or could have dragged you in the court judiciary. So it determines the circumstances in which promises are made and they are made legally binding. The Act as enacted originally had 266 sections, and now these 266 sections have been further divided. From section 1 to 75 deals with the general principles of the Contract Law or Contract Act that we are going to discuss later on. The second part you can say that is from 76 to 266. These sections of Indian Contract Act 1872 deals with factors like special kinds of contracts. It deals with contract of indemnity and guarantee, contract of bailment and place, contract of agency. Coming to the next slide. Now, as per the Indian Contract Act 1872, I would tell you the definition of this Contract Act. The Indian Contract Act 1872 describes contract as an agreement enforceable by law. If the agreement is not enforceable by law, then it won't be considered as a contract. So, Section 2H of the Contract Law of India describes contract as an agreement enforceable by law. Means these two elements makes a contract. Further, a contract is an agreement creating and defining the obligation between parties or between two individuals as well. A contract is an accepted proposal agreement that is fully understood by the law and is legally defined or enforceable by the law. Means it should be so much simple, or it should be in legal language, so that law could understand that what agreement were made between the two parties or two individuals, so that law could not face any problem in interpreting the situation, in interpreting a agreement or offers. I have made a simple diagram or ray diagram of the process of contract, how the contract is formed. So, for making a contract, first offer and proposal is put forward. Means one party or any one individual put a offer in front of his friends or in front of his counterpart or a party. Then offer could be either accepted or rejected. If rejected, then there is no question of contract. But if it is accepted, then you can go ahead for the contract. You will go ahead in the process of making of contract. If offer is accepted, then an agreement is formed between the two parties. And this agreement, when done legally, when made legally enforceable by fulfilling all the legal formalities, then it makes a full-fledged valid contract. So in simple language, you can say an offer is made by one party to another, which when accepted by the other party to whom it is made, leads to the agreement, and if that agreement is enforceable in the court of law, that is known as contract, the topic in question. So this is the simple process of contract making, formation of contract. Now I have just used a term valid contract. So for being a contract to be a valid, some basic elements, some basic components should be there in place. And this diagram roughly says that what all basic elements of a contract should be in place, ranging from agreement should be there, free consent of parties should be there, the parties should be competent enough to meet the requirement, thereafter lawful consideration, lawful object should be there, and not declare void express. So these through these six essential points, we can understand that if these elements are there, then a contract could be said as a valid contract or a genuine contract. Otherwise, your contract could not be legally binding, could not be legally enforceable. Now, let me express these terms briefly. Agreement, the primary element is agreement, and it creates a contract between the parties, which is a result of offer and acceptance, as I have discussed in the process. First offer is put by one person, another person accept it, and it forms consideration for the parties to be consideration for the parties concerned. Consideration means both party must consider this contract to be in place. Free consent. Free consent simply means that there must not be undue influence or force, coercion, or some type of pressure over the parties to go for contract. So free consent just simply says that both parties, two parties, when entering into the contract, should be free from any pressure, any type of coercion, any type of you can say any type of undue influence. So consent means the parties entering into the contract must agree upon the same thing in the same sense. The consent of the party is said to be free when it's not influenced by coercion, undue influence, any fraud, misrepresentation or misleading information, or by mistake. Means on various basis a consent could be influenced, your consent could be wrongly interpreted. So under free consent, there must not be existence of coercion, undue influence, any type of pressure, any misleading information, any mistake, any misrepresentation. So free consent is also a required criteria for being a essential contract, being a valid contract. Third factor is competency. If two parties are entering into the contract, suppose if I agree with my friend that pay me 10,000 crores and I will make Taj Mahal for you. Is it my capability to make the Taj Mahal for my friend? Of course, it's beyond my capacity, it's beyond my competency. So that's why I am not the right person to enter into this contract. And on this basis, on the basis of my capability, my competency, it's not a valid contract. So competency refers to the capacity of the parties to enter into the contract. On some other factors like a minor cannot minor that is below 18 age cannot make a contract. Some other persons can also be disqualified from contracting, like alien enemy. Alien enemy are those persons who are living in our country. Suppose a Chinese national is living in our India and a war broke out in between India and China. So that person will become alien enemy and he would not be a genuine person to enter into the contract. Consideration, lawful consideration in fact, that is agreed to be paid for the promisor's obligation by the promisee. It must be adequate and lawful. So consideration must be lawful. Both the parties should be considered should consider the contract in lawful manner, and promisor, those who make promises to the promisee to which promises are made. Lawful object, very interesting thing. Lawful object, suppose if I make an agreement, I make a contract with a person to kill one of my enemy and I will pay that person 1 lakh or 2 lakh rupees. In this situation, if the criminal whom I give money 2 lakh rupees and I wanted from him to kill someone or the person who is my enemy. However, it is a funny example. Don't take it seriously. So, if it happens and the criminal failed to fulfill the task what I had given to him and he has taken away my 2 lakh rupees as well. In this situation, I would be very much frustrated, and if my work is not done, if I go to the court to say that this criminal didn't fulfill the my job and as per the contract I had given him 2 lakh rupees, but he could not kill the person or could not kill the enemy. In that situation, court would either drag me to the jail and may take serious action against me. So we see that here lawful object or lawful consideration is missing. We can make a contract for genuine things. Suppose if two persons are doing contract for like illegal objects, like you can say various drugs are there that can destroy the health of youngsters. So drugs, arms and ammunition which are illegal in our country, we cannot enter into the contract considering these unlawful objects. Then comes not expressly declared as void, and the law should not expressly declare the contract as void. In some situations it becomes like a restraint of marriage, trade, etc. So these 6 conditions are main elements, main components of a contract. But apart from that, some other factors can also be considered. Like we see that there must be at least 2 parties to constitute a contract. Means at least 2 parties should be there. I cannot make promises to myself. I cannot make agreement to someone who is not available in this universe. The parties entering into the contract must intend to create a legal obligation. If legal obligation is missing, then again a valid contract cannot come into action. It must be in written form. When you have to do a proper contract, it must be done on legal papers, stamp paper or promissory notes, whatever is applicable. There must be certainty of meaning. The terms of the parties must be clear to the parties. The parties should not interpret anything wrong. For this, there must not be miscommunication. Whatever message the one party wants to convey to the second, It should be clearly understood by the other one, should not be interpreted wrongly. If it is interpreted wrongly, the expectation could be different. There should be a possibility of performing the contract, means there should be possibility of contract. The parties should be capable enough to fulfill the conditions of the contract. Like I told that I cannot make the Taj Mahal, so I should not enter into a contract where I will be given money to make Taj Mahal. Now, some main types of contract I have shown in this diagram. You see that Contract Act or contract law are of various types and on various bases. First, on the basis of validity. When we see the partition of contract on the basis of validity, it could be valid contract, it could be void contract, it could be voidable contract, it could be illegal contract, could be unenforceable contract. Similarly, on the basis of formation of contract, it could either be express contract, it could be implied contract, or quasi contract is also a option. Some authors also claim that if you are doing e-commerce, then a separate type of e-com contract can be there. I have not included in my chart. And on the basis of performance, either it could be executed or executory, and executory could further be divided into two parts, unilateral and bilateral. So let me explain these types of contracts in simple language. On the basis of validity, valid contracts, this is the simple one. You can easily assume that the contract that fulfills all the criteria of being a contract. I had discussed that free consent should be there, lawful consideration, lawful object, apart from competency should be there. If all the elements are there, nothing is missing, then the contract is valid. An agreement which is enforceable by law is valid contract. And you can add up one more point, that it must contains all the essentials of being a contract. That makes the valid contract easiest one. Now coming to the void contract. Void contracts, as the name suggests, this is not a valid one. This is contrary to valid one. It might be possible that at the starting of formation of the contract would be a valid contract, but later on, because of missing of some factor, it becomes void. Like the contract which is no longer enforceable in the court of law is void one. To explain this, I would say that suppose I made a contract with a farmer that I will pay him 1 lakh rupees, or even I paid him 1 lakh rupee, and thereafter I wanted him to, whatever crop is produced in his field, I will take away after the 3 months. He did his work, and but because of act of nature, because of rain, the whole field was destroyed. Now in this situation, I had given him the money, but in return I could not get the yield of his field. Then in that situation, it is no longer enforceable in the court of law. I cannot drag this person to the court that he is the culprit, he could not give me the output what he promised me. Earlier that condition was lying, but because of some factor that is beyond his control, this thing happened and the contract become void. The contract become null. Now see, the third one is voidable contract. Voidable contract is a contract in which one of the parties to the contract has a choice to avoid performing his or her part, then it is termed as voidable contract. When the consent of the party is not free, the contract becomes voidable at the option of the aggrieved party. Let me make it simple. Suppose one of the key element is free consent, and if I am forced to sign a paper of my property by criminals on gunpoint. The criminals have taken me at the gunpoint, and thereafter they want me to sign on the papers of property. I can do it. I will have to do it. Then at this situation, the free consent is missing, and even coercive environment is there, forcefully and under pressure. The contract I have been forced to enter into the contract. In this situation, I am the aggrieved party, I am the person who is the victim, and in the eyes of the court, I am free to deny this contract, and it all depends upon me either to go for this contract or just revolt against this contract. Coming to a legal contract, the contract which is forbidden by the law is termed as a illegal contract. Like if you are entering into the contract for selling of drugs, selling of uh, non-allowed arms, then these are the part of illegal contract. Or one more example, what I had given, if you are making contract, if you are forming a contract for killing someone, then again it is a type of illegal contract where the object in question is illegal. Unenforceable contract, the contract whose substance is good, but due to some issues it's not as enforceable and is called unenforceable. Sometimes so happen that if you make a contract, you have to sign on promissory notes, you have to sign on papers, legal papers. If some stamp is missing, signature is missing, in this case it is enforceable, but some technical problem is there. Unless and until this technical problem is removed, is eradicated, the contract cannot be enforceable. So the solution is that just if a stamp is missing, put the stamp there. If signature is missing, get the signature there, so that technical issues can be resolved and thereafter contract could be enforceable. So these are the 5 types of contract on the basis of validity. Now going on the types of contract on the basis of formation. On the basis of formation, contract are of 3 types: express, implied and quasi contract. Express contract are those contract which are in written form, which are in a spoken form generally, and we know that most of the contracts are in written form. So it must be expressed, and expression can be done either orally or writing. So these are the express contract. Against this, or in contrary to express contracts, implied contract is there. In implied contract, the contract which is constituted by implication of law or action. Let me take an example. If you are riding a bus, you don't put your signature with the bus driver or bus conductor that you have to go to this destination and I will pay this much rupees. So nothing, there's nothing like this. No such drama happens. Rather, if you are entering the bus, you know where the bus is going, you know what is the fare, and at this situation, it is implied. It is already known, and it's not to be expressed by anyone, any of the party, that what is to be done, where to go, how much fare is to be paid. So this is a type of implied contract. Once you enter into the bus, you enter into the contract. Quasi contract. This is very, you can say, sometimes say that confusing contract, means whether it is a contract or not, because sometimes people say that it is made on the basis of your moral responsibility, legal responsibility, because either of the parties don't go for making a formation of contract, but it happens because of some event, condition, incident. So these are not real contract, but they are identical to a contract which is formed out of some circumstances. Now again, I give you an example. Suppose in quasi contract, you suppose you are an interviewer, and a person come to you for an interview to have a job. But what happens, you didn't select him, but you find that some documents are left in your office. It could belong to any of the candidates came for the interview. Now, as soon as you find this document, you enter into the quasi contract on moral responsibility, on legal responsibility, to return that document back to the person who left here. So neither of the person intended to come to this contract, but by virtue of the circumstances, this quasi-contract is formed. On the basis of performance, executed contract, executory contract. As the name suggests, executed contract, that is already executed, both parties fulfill their commitment. I had to sell my property. The person who wanted to purchase my property paid the money to me, and everything is done as per the agreement. So then this is the example of executed contract. But imagine a situation that I have to sell my property, and the person who is interested, he has paid me the money, but since I have to make this property fully furnished, I have to do some form of reformation there, renovation there. So I would keep him waiting for some time, and in this case the contract is not executed yet, so it is executory from my part. So it is type of unilateral contract. Executory is of two type: unilateral contract and bilateral contract. If either of the party is missing from his part, could not fulfill his part, then it is unilateral. In the last example, I was the person who took the money, but still I could not hand over the property to the person with whom I am in contact. I have entered into the contract. So that is an example of unilateral contract. One person fulfilled his responsibility, but I could not do. In future, I will do it. In bilateral contract, situation could be a bit different. Like suppose I have to purchase a flat in a society. I have paid just token amount to him, 2 lakh rupees, and remaining 38 lakh rupees I will pay later on. And the possession of the home would be given to me after 2 years or 3 years. So we see this in this case, both the parties could not fulfill their commitment, their work, what they had to do, they were supposed to do. So this is executory contract of bilateral type, in which both party could not fulfill their contract at this point of time. Yes, in future it could be transformed into executed contract. So that was all through which I wanted you to understand the contract and its types. One more important topic is laws at workplace. Means what are the laws that is applicable to you when you enter into a workplace, when you join a job, when you become an employee of a company. So in India, there are various labor laws, and India is known for its strict labor laws that favors labor. So the Indian labor laws are made to define clear-cut relations between employees and employers. Indian labor laws are made to safeguard the interest of the workers, and there are following important labor laws in our country. So many labor laws are made so that employees can feel safe at the workplace, can safeguard their interest, can fulfill his commitment, can do his work without any stress. So some important labor laws are there. Workers' Compensation Act 1923, the Trade Union Act 1926, Payment of Wages Act 1936, Industrial Employment Act, that is also known as the Standing Order Act 1946, Indian Industrial Dispute Act 1947, the year when our country got freedom, Minimum Wages Act 1948, Factories Act again in 1948, Maternity Benefits Act 1961, and for the benefit of women workers, that is a good step. Payment of Bonus Act 1965, Payment of Gratuity Act 1972, Sexual Harassment of Women at Workplace Act 2013, and apart from that, lots of other laws are there to protect and safeguard the interest of employees at the workplace. Let me explain a few of them. The Trade Union Act 1926 is a very strong medium to save the rights of employees. These unions have the power to compel higher managers to accept their reasonable demands. Article 91C of the Indian Constitution gives everyone the right to form associations or unions. The Trade Unions Act 1926 amended in 2001 and contains the rules on the governance and general rights of trade unions. In simple words, we can say that the Trade Union Acts helps employee to remain together and fight for their rights in group, and it safeguards the interests of trade unions as well as worker in group. Payment of Wages Act 1936 ensures that worker must get salaries and wages on time without any unauthorized deductions. Section 6 of this Wages Act 1936 says that workers must be paid in money, not in kind. They should not be given just praise. They should not be given motivation, or they should not be given words. Rather, they should be paid in form of compensation. Industrial Dispute Act 1947 has the provisions regarding the fair dismissal of permanent employees. As per the law, a worker who has been employed for more than a year can only be dismissed if permission is sought and granted by the appropriate government office concerned authority. Means it makes the worker's life easier at the organization. He could not be fired, and if there is a genuine reason, then only such hard steps could be taken against the employee. A worker must be given valid reasons before dismissal. An employee of permanent job nature can only be terminated for proven misconduct or for habitual absence from the office. And again, the employee would be given a chance to prove his innocence as well. Some more acts like Minimum Wages Act 1948. This act ensures minimum wage salary to the workers of different economic sectors. State and central governments have the power to decide wages according to the kind of work and location. It depends upon the state, like you will see that minimum wages for UP and Delhi and some other states are different slightly. This wage may range between rupees 143 to 1120 rupees per day. The minimum wage can be different in states to states. The average per day wage rate for unskilled work under the Manrega is set to rise 11% from 182 to 202 for 2020 to 21, and later on it's been upgraded by every passing year. Maternity Benefits Act 1961. This act entitles maternity leave for pregnant women employees, that is full payment despite absence from the work. And we know that women could be absent. It is the call of nature that women should take rest during the pregnancy time, and government has taken right step to safeguard the interest of women during the maternity time. As per this act, female workers are entitled to a maximum of 12 weeks, 84 days of maternity leave. All the organized and unorganized offices that have more than 10 employees shall implement this act, and for large to medium organization, they have to follow this rule. So this law protects the job of the female workers during the pregnancy and post delivery. This act has been amended in 2017 as well. So this is one of the important act that's take care of motherhood. Apart from that, lots of other laws are there at the workplace that is applicable to all employees, be it be me or any one of you who is already employed. So that was all what I had to offer in today's video lecture. Thank you all.